Good afternoon, everybody. This is James Pittman, co-founder at Docketwise. Today's Thursday, June 23rd, and we're here with our monthly webinar. Today's topic is called Pitfalls for the Unwary. And today we're going to talk about common mistakes that attorneys make when they begin the practice of immigration law, and hopefully help those of you who are getting into the practice to avoid making some of those mistakes, or give you food for thought as to things to watch out for, because some of them are small mistakes, some of them not so small mistakes, and they can cost you valuable time, valuable money, and or even worse, hopefully not worse, but maybe worse. So we're going to go through a number of topics, and I have as my guest here Angela Adams. And let me introduce Angela and give her a couple of minutes to just tell us about herself. Angela, introduce yourself. Where do you practice? And what is your practice like? And how did you get into immigration law?
Thank you, James, and thanks for the invitation to be here today. My name's Angela Adams, and I practice immigration law in Carmel, Indiana, which is north of Indianapolis. And my practice is about 50% employment-based immigration. We work with universities, large corporations, very small businesses, landscaping. I mean, it ranges: IT, physical therapists, faculty, staff of universities, student visas. And then about 50% of the practice is what I consider the humanitarian or individual family-based cases. And we do have quite a few asylum cases and TPS and things like that, consular processing and all of that. What we don't really do, we don't do real EB-5 or H-2B, because those of you who practice immigration law probably understand why.
Right. Those tend to be the people who get into those specific niches, that tends to be pretty much all they do, or a very large part of what they do.
Right.
Yeah. And that's the water gets very deep on those. But how many attorneys do you have in your practice right now?
We're a small practice. We have 2 attorneys, and then we have 5 support staff right now. Mm-hmm. And I have been practicing for about 20 years. I started out with a mid-sized law firm downtown Indianapolis doing immigration work. I was there for 12 years. And then I joined in-house counsel at Indiana University, where I was the first immigration in-house counsel for the university, doing faculty, staff, and physician matters. And then about 3 years into that, I decided to jump out on my own and start Adamas Immigration Law. And that was about 5 years ago.
Mm-hmm. And what was it about immigration that just attracted you out of all the fields of law?
Well, I always was interested in culture and language. I do speak Spanish. I spent some time in Spain. I lived in Mexico. I was married to a Colombian. We're no longer married, but that was my experience with my firsthand experience with immigration, traveling, being an immigrant myself, and then having been married to one, and then working a lot with international student populations, and just kind of fascinated by immigration. And 20 years ago, there weren't as many immigration attorneys as there are today.
Right. Yeah, very similar to my own story. A lot of the same interests as far as just really enjoying a sort of an international milieu and interacting with people from around the world and being fascinated by languages. Very similar. Mm-hmm. All right, great, Angela. Excellent story. So glad to have you here. Let's talk about some of our pitfalls for the unwary. So there are a lot of different kinds of mistakes that you can make. Let's talk about legal pitfalls. These are things like legal red flags that you should watch out for when you're considering taking on a case. A case walks in the door. So, one thing I always say is make sure you're aware of the entire record of proceedings. And by all means, if you feel like you need the record of proceedings, make your FOIA request. You can submit Freedom of Information Act requests to many of the agencies, to USCIS, to the EOIR for the record of proceedings of an immigration court case, to Customs and Border Protection, for entry information. And do you have any tips or anything you would say as far as legal pitfalls, screening cases, or obtaining necessary records to evaluate a case?
Yeah, I think to add to that long list is the FBI rap sheet. Mm-hmm. And one thing I have found is, from experience is don't rely on what your client tells you about or doesn't tell you about their criminal history, because they could very well not understand something or leave something out. They may have thought that it wasn't an arrest or a conviction, and it absolutely was. And you don't want to find out from the immigration judge that your client has a criminal history standing there in the immigration court for the very first time. So you want to do your homework, do that FBI rap sheet. It's easy, and actually you can order the kit. We do it here in our office, and we have the client come in and actually do their prints and send it in and get that back. And it just takes the surprises out of, you know, any criminal history. And if they were ever detained at the border, usually that's noted on their rap sheet as well, if they've been in proceedings.
Yeah, I've actually seen where a rap sheet came back and actually had the A number on the rap sheet, and that was the way that we finally obtained someone's A number. So yeah, good tip. If you think you're going to need to run rap sheets frequently, then you may consider buying a fingerprinting kit. They're a few $100s, and you can watch a video on how to take fingerprints. There's a bit of an art to the technique, you know, rolling the fingers on the ink and so forth. Otherwise, you can check around in your local area to see who takes fingerprints. I mean, sometimes there are, if you're in a city that has a immigration field office in it, there may be trucks. I mean, I know in Philadelphia here, we had a truck that used to take the fingerprints, and you could get them done there, or there may be other places where you can get fingerprints done. But I would definitely do that. Yeah, I mean, it's also true, you know, if the client goes in for a routine interview and they have some sort of an outstanding criminal warrant, you know, they can be called on it right at the interview. I've actually seen people get arrested right in USCIS offices on a routine adjustment case because they had some outstanding warrant that they never revealed. So you don't want to be in that position finding that out. Make sure the client asks what you're asking. So if they, you know, use language, make sure you question them in several different ways. You know, you want to ask about convictions. You want to ask about arrests. You want to ask about any charges, any contact with law enforcement being local police, federal law enforcement, or ICE or CBP.
And another thing you can ask is, have you ever been fingerprinted? Because sometimes that's an indication as well. They may not understand that the fingerprinting was as the result of an arrest.
Yeah, absolutely. Now, Angela, when someone comes in with a case, what would be some, you know, sort of red flags aside from criminal history that, you know, you would make you think twice about handling a case? I mean, how do you structure your case evaluation? I mean, people come in, you don't just automatically say yes to everyone who walks in the door. You can't do that. So what criteria do you use for determining when a case might be something that you don't want to get involved in?
Well, the first thing I learned very early on, that I should charge a consultation fee. And I've also learned over the years that it's probably better to try to get them to pay the consultation fee before the consultation, so that there's a better chance that they will actually show up for the consultation, because there's a lot of no-shows if you don't get the confirmation and the payment up front. My one indication is if they can't pay the consultation fee, or, you know, they're having trouble with finances, this might be a client that you refer out, that you give them other resources that may be pro bono or low bono in the area. Because if you're a private practice attorney, you don't want to be in that situation where you're trying to collect your fees later.
Yeah, absolutely. It's so true. I mean, first of all, your time is valuable, including the time at the initial consultation. My experience was the way that people come in is the way they're going to be all the way through the process. You know, you're not going to reform their attitude. So if they're objecting to paying you a consultation fee, you're likely going to have further problems with that client over payments in the future.
Yeah, and also if they're treating your staff in a very unprofessional or rude manner, I find that to be an indication that someone may be a difficult client to work with in the future. You have to kind of temper that with, you know, what kind of a case is it, and the anxiety that goes that people are facing and what they've been through up until this point. But there's no reason for rudeness, and there's no reason for demands and for people to be, you know, not nice.
Yeah, you as the attorney set the terms of the engagement. I mean, you have to communicate to the potential client how you do business, on what terms you can provide services to them, and then they agree to it, right?
Right.
The client doesn't dictate the terms of the engagement. That's
Exactly.
really important to remember.
Exactly.
Because when you're new and you're starting out, you want to get the client, but you certainly cannot just do whatever the client wants you to do. That is just not how it works. And you're setting yourself up for problems if you don't set the terms of the engagement.
Exactly.
All right, let's talk about clerical errors or quality control in the office. You know, immigration requires a lot of data collection, and certainly we have a lot of technology like Docketwise nowadays, which helps us to do the data collection and makes our lives a lot easier. But we still have to engage in a quality control process. I mean, you as the attorney are still responsible to make sure that information that is being submitted to the government is accurate. And that clerical errors don't escape your staff's notice. So what safeguards, Angela, do you have in place, or would you recommend to make sure to minimize or hopefully eliminate these type of errors?
Well, first of all, I think it's important to note that mistakes will happen. You can't avoid mistakes altogether. Now, you're trying to minimize the amount of mistakes that your office makes and make everything flow. But the question and the issue is really, what do you do when the mistake is made, and how do you treat that, and how do you own up to it, and how do you learn from it so that it doesn't happen again and you don't repeat the same mistake? We've had, I mean, it's embarrassing when you check the box female instead of male, or, and then it happens that the person's card is issued with the incorrect spelling of their name or something like that. And it makes more work for everybody else. You have to go back and the client's unhappy. Or for example, if a case is rejected because something wasn't, a box was missing, or a check was left on the copier or something like that. Those are all things that, we try really hard not to do, but inevitably everybody's going to have at least one, right, big mistake that they're going to have to live through and work through. We try to kind of implement this, what I call second pair of eyes, right? You should never be the only person looking at a case. You should always, I don't care how good you are. I don't care if you're new, young, old, I don't care who you are. If you've been doing this for 30 years, everybody makes mistakes, and you must have a second pair of eyes on your work, because you're going to miss something because you've looked at it so many times. And have someone else review it for you. Have someone else go through it. And then you as the attorney, I'm ultimately the one signing off on everything. So I trust my staff, and sometimes I trust too much, right? And I don't look at every single box, and I need to do that. I need to go through, and I need to, because I'm signing the forms, and ultimately it's my responsibility what's being submitted to the government.
Yeah, I mean, I think that's a very good practice. I mean, the staff can be working up the packet, preparing the packet, putting it together, and then someone from the staff can do an initial review, and then it should go to you as the attorney to go through the packet and do a review. Now, if you find something wrong and you send it back to the staff to correct it, once they correct it, make sure that you then review it again, right? It should be a repeat of the process. Like, it didn't get through your review the first time, so now you're going to go back and review it again after they've made the corrections. That's how you, and have physical space in your office set up so that, cases that are scheduled for final review are in a certain location, and you can go through them in a comfortable environment and just focus your mind to make sure that you're catching the errors.
Yes.
And, because the consequences of, something like forgetting to attach the photographs or something, or forgetting to attach the check, the packet's going to be sent back. The client will get a rejection notice. They will blame you. It makes you look bad. You may lose the client.
Yeah.
Okay.
And one other thing I always say is, you want to be the first person to tell the client the bad news or good news. Either way, good news or bad news, right? You get an RFE, your staff, somebody at the front gets the mail, right? They go through the mail, they make your mail notes or however you document your mail. And then they contact the client, say, here, we got an RFE. And you're like, no. I need to be the one, especially if that RFE is asking for something, because a lot of times we know they ask for things we already submitted. And so the client's going to come back and say, I gave you that. You have those documents. Yes. And you want to make sure that you're dealing with the client, because they're going to be anxious and they're going to be nervous and they don't know what this means, or if it's 6 pages long, but it's all, you know, this mumbo jumbo, and then it's really just a couple paragraphs of a significant request. You want to be the one to deliver that message, not your front desk person. Or
Yeah.
you don't want it to go in a file somewhere and have the client call you and say, what's this thing that I just got?
Right, exactly. No, I mean, that's very good advice. And I think when an office action comes in, request for evidence or a decision, you should, as quickly as possible, review it, think it through, formulate some sort of a message that you're going to transmit to the client, and get the client on the phone as quickly as you can. You do not want time to elapse, then the client will receive their own copy in the mail. They will not have had the benefit of you delivering the message, and they will formulate a reaction without the benefit of your guidance. So how you deliver the message is so important, and hopefully you can formulate it in a way in which, you know, if you have already submitted things, you know, you're communicating to the client that we've got this under control, they've made a mistake, or we know how to respond to this. You control the messaging.
Yeah. And a lot of that is also setting expectations up front too, being clear about fees, being clear about what happens if this, if that, and that, you know, maybe in 70% of the cases get RFEs or something like that, so that the client isn't completely blindsided when they receive something.
Yeah, I think setting expectations and setting them accurately at the outset as to, you know, what a possible chance for success is. I mean, if the client has a weak claim and they're coming to you and they want you to, and you know that there's a substantial likelihood of an RFE or possibly a denial, you need to set that out for them and give them an accurate assessment of how strong their claim is. And tell them, you know, if you're planning to accept the case, I'm accepting the case, but you should know no outcome is guaranteed. And furthermore, I can see some weaknesses in your claim. Let us try our very best and hope for the best, but setting the expectations, and also make sure that your retainer agreement covers various contingencies that could arise.
Right.
You know, if
I would actually put that in writing. I would actually do what we call a CYA letter, right? You do the CYA letter. So you say, the client can't come back and say, well, you told me this. And you say, no, I've got it all right here in writing.
Yeah.
I told you this.
That's a cover your butt letter, but I mean, it can be in the form of a memorandum of understanding.
Right.
Yeah, I've given them a memorandum where I've said, you know, we met today and I explained this and this about your case. And I told you that, you know, this and this were weaknesses, and you understand that there are no guarantees and so forth.
Yeah.
Definitely good to go into things with writing, and have your retainer spell out. Make sure that your retainer itemizes, you know, what the fees are, and if various scenarios emerge, if there's a need to appeal the case, if there's a change in the law, if multiple RFEs are received and the time needed greatly exceeds the amount that was contemplated at the beginning, make sure you have some contingencies in there so that you are able to be compensated for the additional time, and you don't have cost overruns or or a surprised client.
Right. Yep.
Let's talk a little bit about some of the ethical pitfalls, and this obviously could be a whole session on its own. But you know, there are some particular aspects of rules of ethics that you have to watch with immigration law because of the types of scenarios that come up. I mean, first and foremost, you want to make sure that you're competent. I mean, especially if you're new to the practice niche, make sure that if you're taking a case, you have a firm understanding of what's involved. I mean, if you haven't handled many of those cases, obviously have information, have mentors available that you can consult with in case something happens that you're not sure how to handle. But you want to make sure that you've sat through the CLEs and you are competent. You don't want to just sort of, go in blindly to something like a complicated criminal removal case with complex issues about federal and state criminal laws and something. If you're totally unfamiliar with that area, that's getting too deep. Start out with things that are more straightforward and make sure that you are being educated before you undertake. That's first and foremost. Second of all, You need to keep client information confidential. And let me pose this to Angela. What safeguards do you have in place to make sure that client information is always kept confidential?
Well, we've got a lot of institutional clients that are very, very protective of personal information. And so we make sure that we don't put that substantive or personally identifiable information in an email, that we use SharePoint. There's various other ways of securely sending information like social security numbers and other sensitive information, and just make sure that that is in a safe space. Also, just saving everything in the file, in your SharePoint file. And Docketwise is another very good tool to upload documents, have the client upload their documents to the cloud, and just to make sure that you have layers of safety there.
And do you, at this point, Angela, do you have are you keeping full physical files, or do you have more like skeletal files, or you're entirely digital?
It depends. We have some skeletal files that are, the easier matters that we can save everything on SharePoint, or we've got the larger files, as you can see behind me, that maybe we are removal defense cases that we had to file paper copies, or and here in Indianapolis, I think all USCIS is still paper. So if we go to an interview, we still have to make a copy of the petition, and I have to take it with me so I can go through it with the examiner, with the officer during the interview. So we do still have a lot of paper, but we're trying very hard to make sure everything's scanned and saved. When we close files, obviously we have a shred system. We don't want to throw away in the trash somebody's, confidential information. That's pretty basic, but the shredder is, there's shredding services that you can order, and they'll come get your stuff and they'll take it. And then you just have to make sure that that is not out there in the open.
Mm-hmm. Absolutely. Now, with the physical files, is anyone permitted to, like, if someone's working from home, is anyone permitted to take the physical files out of the office? Any employees?
Yes, they would be, but usually everything we have is on the SharePoint.
Okay.
So most of the time we don't need to take physical files home.
Okay.
Most of the time we'll just have everything we need electronically.
Oh, good. Okay, great. All right, let's talk about conflicts of interest. And there's two main types that come up. There's conflicts of interest that come up between individuals, like, for example, the classic example is the marriage case that breaks up, the marriage breaks up, and then the VAWA, someone claims abuse or domestic violence, and then they want to file a VAWA case. That's a conflict of interest. And then the other conflicts of interest that often come up are with the employment-based cases, where you're representing the employer and the employee wants to seek your advice about something. So let's talk about those. Let's start with the second one first, Angela, about the employment-based. So you're representing. Do you represent mostly you're representing the institutions?
Yes.
Is it always, is it like an ongoing engagement where the institution would have a number of cases over time, and you consider the client to be just the petitioner? You don't consider, do you consider the beneficiary your client or not?
No, typically we consider the employer our client.
Okay.
And so when we do I have this happen a lot, where the employee will reach out to us directly and ask questions, or want certain information sent to them directly. And we always go back and say, please, contact this person at your employer first before reaching out to us, or make sure they're in the loop, because we don't want to have communication that where the client, which is the employer, is not in the loop. And in addition, it leads to overuse, right? The employee is oftentimes reaching out to the attorney too much, or just whenever, and trying to check on status of things, or anxious about when the filing is going to go out the door, or whatever. It's nice to have that kind of control of the go-between, the person that's the gatekeeper at the employer, that will kind of answer those questions and then come to me if that person cannot answer those questions.
Now, do you file the adjustment applications for the employees?
That's a great question. We do. And so early on, when I was in-house counsel at a university at IU, that was one of the very first questions we explored was, would it be a conflict of interest for us to do all the PERM, the I-140, and the 485, or do we want to send the 485 out and refer that out as an individual matter? I am aware of certain institutions, of another very large institution in Indiana that does it the other way. They do the PERMs and the I-140 in-house, and they send all the 485s out. Most of the employers that I deal with, they typically like to handle all of the process and all from beginning to the issuance of the green card. And so we do the 485. And at that point, and sometimes it would be beneficial to do what's called a mutual representation agreement, where you outline who your obligation is to and in what situation you're going to maintain confidentiality. Like my first obligation is to the employer, and my representation is limited. It's a limited representation agreement with the employee.
Mm-hmm. Yeah, this goes to the issue of kind of the golden mean of, there was an article by Cyrus Mehta years ago called The Golden Mean in Dual Representation, where you kind of, to represent both parties, you have to sort of spell out what the responsibilities are to each party. And then you have to be wary of this kind of situations which can come up as sort of like late stage portability, where the employee is thinking of leaving and going to another employer, and they want to ask you specific advice about what can happen if they leave their current position. Have you ever had to deal with that?
Oh yeah, definitely.
What do you tell them?
Well, we tell them you really can't have this conversation with you because everything that you tell us is not confidential because we represent the employer. So we advise them to seek their own immigration counsel.
Mm-hmm. Is it a practical solution for the employee to engage separate counsel to do just the I-485 when you've already handled all of the others? I mean, has that ever happened?
Sure. And it depends. Like that one employer, they send them all out. They send all the 485s out. They're responsible for getting their own attorney for the 485, or doing it on their own because the employer doesn't handle it.
Mm-hmm. Okay. So it can be the employer's choice as to.
Yeah. I think so. Yeah, I think so. As long as there's no inherent conflict. I don't think there's an inherent conflict. I think a conflict could arise later that you need to be aware of, especially if you represent multiple employers that employ the same type of individual, and you have the employee going from one of your clients to another one of your clients. Then what happens?
Right. Yeah, that gets tricky.
Recently came up, and I said, and what we determined was that once that employee had given notice, and it was an H-1B situation where H-1B is pretty clear you represent the employer, not the employee. Right. But the PERM is when you get into that wonky, I-485, who's the client type thing. And so I think for the H-1B, it's pretty clear. If they give notice, then you're safe. But the moment they start to engage you before they've given notice, or if then I think you got to step back and go, nope, can't advise you on that.
Yeah, it's super important, and those things get complex. So it's best also to spell that out in a memorandum, a dual representation agreement, if that's what you're undertaking, and spell out what the scope of representation is via each party. Mm-hmm. Yeah. Yep. And familiarize yourself, make sure that you carefully read the state rules for conflicts of interest. Let's talk about the family-based conflict of interest. That example I gave, that's the classic example of the marriage and the VAWA case. Have you had that come up? Oh yeah, many times. And we were very careful. I just stopped the person from talking, and I kind of just say, hey, and I'm trying to be very sensitive because it's a really emotional situation many times, or depends on which party is calling you, which spouse, the abused spouse or the one that's actually the abuser. And so usually it's the abused spouse calling you saying, things aren't working out for me. I don't know what to do. And then you kind of have to stop and say, I'm really, really sorry.
I'm so sorry to hear this. Are you safe? And I really can't, and you have to explain to them why you can't handle it. Because at that point, you tend to have a relationship established with them. If you've already filed a case and you know the spouses, you might even really like them both, right? You've represented them and they've come to trust you and they want you to continue working with them on their case. And you have to just say, I really can't. Once I've got a legal agreement, you're both clients and I can't do anything adverse to the other, to one to the other. And so what I do is I say, I'm going to send you to somebody who, I'm going to refer you to someone that I know will help you. And it's a very good attorney, or give them a couple names. And then you give that attorney a heads up and say, hey, so-and-so is going to be contacting you. This is a sensitive situation. I have a conflict of interest. Please take good care of them. Something like that. And usually, that's how it, you just have to say, I'm sorry that I can no longer. And here's the other thing. It's really important, James, is put it in writing, because a lot of times, and if it's a valid situation, you have to be really sensitive to that, because you do not want to endanger that person at all. You don't want to make it unsafe for them, to cause more harm. But if it's not a vow and it's just a breakup, right? A client, they're breaking up, or something happens, or you find out that maybe they are not living together, or maybe they lied to you or something. Always put that in writing and terminate the relationship so that there's no question that you no longer represent this person, and include information about whether or not the fees have been spent and how much you have done, how much work you've done in the case, and that we will or we will not be refunding you a portion of your attorney fees.
Yeah, I mean, even if you're billing flat fees, it can be a good idea to keep track of the time that you're spending. And a lot of attorneys have a early termination clause in the retainer, where if the case is terminated before completion, you are entitled as the attorney to a prorated share of the fees, depending on how much work you've done. So you may want to keep track. Also, keeping track of your time is also a good way to just evaluate how much time you're actually spending on things, and you can go back and judge your flat fees and whether they're accurately reflecting how much time it's taking you to do things.
Yeah.
Also, keep in mind, you can't, I mean, if you've represented people in a marriage-based adjustment of status case, you can't subsequently come back and represent one side in a divorce case, or in a child custody case. So be aware of that if you're practicing in the family law area too. And you can generalize that if you're practicing in other areas too. I mean, if you've had the employer-employee situation and the employee leaves, you can't then represent the employee in a workers' comp claim or some other claim via the employer.
Exactly.
Yeah.
And another thing, I tried one time, because both spouses came to me and said, this isn't working out, but we want you to continue representing us, representing the beneficiary in the 751. Can we agree? Can we sign a waiver of the confidentiality of the attorney-client privilege? And I tried to do that, and I will never do that again. It didn't work out well, and I didn't. I did everything in writing, and I did my homework, and I made sure, and I really did want to help these people, but at the end of the day, it wasn't worth it. It was not worth it. And things ended up going south, even though we didn't think they would. And oftentimes in a breakup or in a situation, especially when there are other things and factors involved that you don't know about, just get out.
Yeah, cut your losses and get out. I agree. Well, there's so many ethical issues we could talk about, but let's put aside ethics for a second and just talk from the management perspective of law practice about hiring staff and some of the mistakes that you can make when you're hiring people. So Angela, how do you go about finding qualified people to work at your office? What would be your top tips and top things to watch out for as far as red flags of hiring people and best practices for hiring people?
Well, I think, so a couple of things come to mind. Number one, we found really good candidates, in fact, in some of our clients. And so as you're working with your clients down the road, they may become your employees. I've got three former clients working for me right now. And they're wonderful people, and we have known each other forever. Also students. Students are great to bring in, law students and also college students for like summer internships, legal intern to help out. They want experience and they're eager and they really, really are interested in this area. So, you know, it's a way to give back and also get some help. So those are two things. One thing I would suggest is that be very careful that you're not just hiring to hire. You're not just hiring to fill a warm body, right? Because that can backfire. Also, you want to be careful that the person is going to be here for a little while, that they're not using you as a stepping stone to get to the next better place and not getting all the experience to jump out and then, you know, get a better position in 6 months. But some of these things you can't avoid either because people move. People move, it's the market, and you just have to provide good incentives and provide a good environment and culture that people want to be in. Mm-hmm.
I mean, I think, yeah, I mean, one thing I would be wary of is taking people who have not had a lot of immigration experience and you're thinking that you're going to train them up from the very beginning, because that actually turns out to be a lot more time and effort than you think, or that it sounds like. I mean, it takes a long, can take a long time for people to get up to speed on how to handle a lot of the paralegal tasks associated with immigration law. And consider out of the box solutions. I mean, think about, you know, remote staff. Think about whether you really need to have the person in the office, or can you work remotely?
Yeah, we have two remote people, and that was pre-COVID too. And it was kind of unconventional. And one of the reasons why she left her former employer was because she wanted to work from home and they wouldn't let her. And so we agreed at the outset, but she had a lot of experience too. I probably wouldn't do that with someone who was brand new, who was right, you know, out of the gate learning.
I agree with you.
Yeah, I think time in the office is important for people who are new and who are learning. But in her particular situation, it's worked out beautifully.
And then when you hire people, is there a probationary period? I mean, do you officially tell them like the first 3 months are probationary, or it's just pretty much, you know, regular employment from the beginning?
I think every hire is a little bit different in my situation because we're small, and I happen to have known my employees. I've worked with 3 of them for many years prior to starting my own practice. So that was not really an issue. For the newer people, yes, I do have a 6-month written into the offer agreement, you know, the offer letter. We have a written offer letter. A lot of attorneys don't. I put a written offer letter. So the terms are there, and they're, you know, everything about PTO or everything about, you know, reviews, annual reviews, when you're eligible, and all of that, holidays, hours that you will work, all of that's in writing. And I think that's really important to do. But yes, in this particular situation, and James, to counter, you kind of said earlier about being careful to hire someone that doesn't have any experience. We recently did hire someone with 0 experience, but she has a paralegal certificate. And we vetted her pretty hefty questions and made sure that she was going to be a good fit. And so I've taken chances on people, and I also had people working at university, 2 people who I didn't choose, right? They were already there. I came in, they never thought they were ever going to practice immigration law. And here I am trying to train them to do these things. So sometimes it works. Sometimes it can work, and you can find really great people. Some people are, if they've been doing this for too long, they're kind of set in their ways. And then it's hard to break them of certain habits.
No, that's true too. Absolutely. I think you brought up a great point, which is to have a employee manual or firm
Yes.
policy manual, that's well worth your time to invest in creating. And there's a lot of sort of canned ones, templates that you can start with. You don't have to sit down and put pen to paper from scratch from the very first word. There are some out there that you can kind of take the sections that you need and adapt them to your circumstances. So it's well worth the effort. And then you have consistent, because when you're hiring people, when you're running a business, you want to be consistent. You really, all kinds of situations can come up, and it is always better if you have a policy manual where you say, this is how we do things, and it's written down in the policy manual, and you apply it consistently across the board. That's going to avoid all kinds of problems if you appear inconsistent or deal with situations with your employees inconsistently.
I think one thing you said earlier, we were talking about outlining the responsibilities of the position, making sure that when you're hiring someone, what are their expectations, salary expectations, and then what are the job responsibilities? Because you don't want someone coming in here that's above making copies, if that's what the position calls for. Because the last thing I want is one of my attorneys making copies,
right.
That needs to be, you need to be very clear on, this is the job. And if it's in the office, it's in the office. If it's making copies, if it's getting the mail, if it's answering phones, that's what it is. So that you have that ability to delegate, I think is really important. And I'm not just that, ability to delegate administrative duties. I think that's really important.
It is really important, because you as the attorney, ultimately it's your firm. And if those things are not getting taken care of, then that's time that you have to spend finding a solution to it, or God forbid, doing it yourself.
Exactly.
Which starts to take up lawyering time. And then things are going in the wrong direction. Yep. Okay, let's talk a little bit about billing pitfalls as far as billing clients. Now, always best policy is to get the money up front to the extent possible and the extent that comports with, your ethical rules and so forth. I always say, do a good job and charge the full value of what your services are worth. That's really, that I think is the one of the main guidelines to follow. I mean, attorneys, especially immigration attorneys, can be of a very sort of altruistic bent, which is wonderful, and you want to help people, and you are dealing a lot of times with people in circumstances that need help, but at the same time, you're running a business, you're running a law firm, you're running a business. You want to be there to be able to provide the services, and in order to be there to provide the services, you have to be operating at a profit, basically, to stay in business. So you want to figure out what your services are worth, be confident in what your value is, charge the full value. I would be wary of doing payment plans. I mean, that's very, very popular for attorneys to do payment plans. And I think if you're going to do them, I mean, certainly if you're going to do them right. Think about whether you want to do payment plans if you're not equipped to do collections. I mean, because when you're setting people up on a payment plan, you're also setting up a scenario to need to do collection work too. Do you have capacity? Do you have someone who can do that collection work for you? I think automated payment plans are the best, where you've put the client's card on file and you're automatically billing them a set amount. Each month they're getting automatically billed. You're not having to send out an invoice and wait for them to get around to paying it. Let me give Angela a chance. So what are your thoughts on getting the money up front, and your thoughts on payment plans?
Yeah, I always try to get, it depends on how much it is or how long the case is going to last, right? If the case is 6 months versus 2 years or whatever. But I try to get half to a third to a half up front. If it's a spouse petition, half up front, half at biometrics. If it's and we do flat fees. I have had a lot of time doing billable hours, and I choose not to do billable hours if I don't have to. So we do flat fees. Try to get the half of it up front and be clear when the other half is due. Definitely charge for your services, because we do undervalue our services oftentimes. And we also don't increase our rates very often. I mean, I feel like I haven't increased my rates in years. And so we've started to do that recently. and say, okay, everything's more expensive right now. The value of the service and everything else that I have to pay for is more expensive to operate. So you got to recoup that.
Yeah, you have to recoup that. We're in an inflationary environment, and that's, that is what you have to do. You have to pass on those costs. How do you handle the government filing fees? Do you have the client, right? And I understand it can be different if you're dealing with institutions versus dealing with individual people. But how do you have the client write a check directly to the government? Do you put the funds in an account and then write a check from the account, or how do you do it?
We do both. We give the client the option. Say, you can either write the check and here's who you write it to. Don't abbreviate because they'll kick it back. Or we invoice them and then we cut the checks.
Mm-hmm. And make sure the client understands that nothing will be filed until, the attorney's fees for that portion of the case plus any filing fees are resolved. Unless you have a giant client that's giving you tons and tons of work and they're on an invoicing schedule where they're only, paying you every 3 months or whatever it is. Other than that, where you have the confidence and the security of having that sort of a client, other than that, you can't be, what's the word? You can't be fronting.
Yeah, exactly.
No,
we don't front filing fees unless in rare situations where they've said it's an institution and I have to get it on file as soon as possible, I'll front the filing fee. But I rarely front because they're so expensive and they can throw off your books.
Yeah, they can.
Yeah.
Absolutely. An institution's different because if you're dealing with a large company or a large institution, they may only send out, accounts payable every once per month, or it can be, even less frequently than that. And yet they may need a petition filed immediately. So you have to, in that situation, you have to file the petition and that they're going to come back to you and they're going to you're going to recoup the filing fees. That's the only exception.
Yeah. Yep.
All right, let's talk about our marketing pitfalls. This is an area where you can waste a lot of money if you're not careful. That's, I think, one of the big things is don't go crazy spending too much on advertising too early in opening your practice. Ultimately, your word of mouth is what's going to produce, I think, the biggest returns for you. You want to identify your target client segment and tailor your advertising accordingly. Get online reviews, avoid bad reviews. If you've ended an engagement with a client on a less than ideal terms and you're afraid they're going to write a bad review, try to head it off at the pass, make amends to the extent possible, provide them some incentive for, to not leave a bad review. Angela, what would be some of your marketing tips and maybe anything, any mistakes to avoid with marketing?
I think as attorneys, there's different attitudes towards marketing. I've heard attorneys say, well, why would we pay someone to do something that we could do on our own? And I don't necessarily agree with that because I'm not a marketing person. I'm not a marketing professional. But on the other hand, there are a lot of things that I don't need to pay for. So try to do what I call free marketing. And if someone invites you to give a presentation, give a presentation. If someone invites you to a church to talk to a group, go do it. If someone asks you for a donation to be a sponsor at a nonprofit fundraiser, do it. There are opportunities where you can give back and you can do good and you can educate people at the same time as putting yourself out there. People get to know you. They can hear you talk. You can earn their trust, and they can see what kind of a person you are and interact with them. And then they're more likely to think of you when they need someone down the road, because they're not going to need someone tomorrow. It doesn't happen that way. They need someone weeks, months, years from now, or their neighbor needs someone when their daughter marries someone from Nigeria or whatever. And then they think, oh my gosh, I know who to call, right? It's the same thing for us if I'm looking for good qualified candidates to hire. People call me all the time that want to be immigration attorneys, and I try to give them a minute or have coffee or whatever, but I tell them, when I need you, I'm not going to remember your name. You need to follow up with me so that I can remember you and I can think of you. You're at the tip of my tongue, top of my head. And I say, oh my gosh, yeah, that's who I'm calling.
But is your marketing these days, is it, is it an SEO based marketing? Is it Google AdWords? Are you doing a lot of digital marketing, or how do you do it?
We're not as good at that as we should be. It's not really intentional. We have a website. We've got a person that updates our website every month. We haven't really engaged in the SEO and the some of those other things. I think over time, getting the reviews, getting the, having good work product, always. Good work product, approvals in cases, gets you more work.
Build your attorney network and get referrals from practitioners in other practice areas too, or in the immigration area for other niches of immigration.
Exactly. Mm-hmm.
Yeah, that's pretty important. I would also definitely want to build up your collegial network, learn how to use LinkedIn effectively, get on LinkedIn, network at lawyer associations, and network outside of law too, in industries where you think you're going to find your clients, especially if you're doing business immigration. You want to be networking in those industries. You want to be at the trade shows for those industries. If you're going to be representing people in IT, you want to be at events that have to do with IT or programming and things like that, letting those people know that you're available to handle their immigration cases. So don't just limit it to lawyers, but get out into the industries where you're going to find your clients.
Exactly.
All right, let's talk about some personal and well-being pitfalls. And these are equally as important as the other areas. I think when you're running your own practice, it is physically challenging, it is emotionally challenging, it is mentally challenging. I think you have to stay fresh. You have to get adequate rest and relaxation. I think if you burn the midnight oil constantly, you're ultimately going to suffer. Your work product's going to suffer. So staying in balance is key. You want to not sacrifice your health. Proper nutrition. Definitely be wary of excessive drinking or even excessive caffeine use. Don't get into the habit of smoking. And those are all important, but you need to stay in balance. You're going to have a gigantic workload. There's always going to be too much work for the amount of time that you have. That is just the nature of things. That's the nature of most businesses, but law practice is definitely among them. And you have to stay in balance and maintain being fresh so that you can think clearly, so that you have energy to do the work, and you have your mood and your overall outlook are positive when you're dealing with clients and handling your cases. What are some things that you can do? I mean, definitely take time to exercise, right? Just wake up earlier. That's important. Don't hesitate to, if you need it, if you need a day off, if there's a holiday and you're debating whether or not to take it, if you really need the time off, take the holiday. You're going to be better off coming back fresh.
Yes.
And more productive too. And I would say, if you have any issues, make sure that you get help for them. There are a lot of avenues available, whether it's counseling. There are some programs sponsored by bar associations and so forth. If you're struggling with an issue, you need someone to talk to, or you're finding yourself, in a habit, or even possibly, an addiction, maybe. You want to get that attended to. Make sure that you're dealing with that, because you don't want it. I mean, these things can, if you let them, they can cause havoc in your practice. They can overtake you, and then you get into trouble. So, Angela, what are some of your well-being tips? What do you do to keep yourself on top of your game?
Well, I'm going to make a little plug here I always think that immigration attorneys should be members of the American Immigration Lawyers Association. That's one very, very helpful tool to having mentors and having people around you that can help you, and that you can ask questions and also talk about things related to well-being. They have resources on AILA about well-being and about taking time for yourself. And then one other thing I would say, yes, I have to worry about myself, but I also have to remember to care about my staff, because they are feeling whatever I feel, they feel. If I'm stressed, they're stressed. If we have too much work, they have too much work. So make sure that you're taking care of everybody on your team, because you're only as good as the people that are supporting you.
Yeah, absolutely. Critically important. I mean, yeah, your staff have the same sort of needs that you have. Make sure that your policies are, reasonable. Make sure that people are allowed to take personal time off, and be accommodating to the extent that you can. And be patient with people, right? Treat people the way that you want to be treated.
Encourage them to get away from their desk for a little while, to go to lunch, to encourage them to go on vacation. It's so important, so important.
It really is. All right, well, we've covered a lot of ground, and we could keep going, but we're nearly at the end of the hour. So this is some pitfalls for the unwary. Hopefully you found this advice helpful as you get into the niche of immigration law. Keep watching for additional webinars. We usually run these at least once per month, sometimes more often. And we welcome your suggestions for any webinar topic you'd like us to explore. But I want to thank our guest, Angela Adams from Indiana. It has been a great hour, and I want to thank also Chris Williams from Docketwise for engineering the webinar today. And thanks, everybody. Thanks for attending. Thanks
James.
for using
Thanks,
Docketwise. Yep. Bye-bye.